Welcome back to the deep dive. Today we're undertaking a really profound and I think challenging exploration.
We certainly are.
We've got a dense stack of sources here, a collection of legal thought, sociological critique, and constitutional analysis, all focused on Brazil.
Right.
And this isn't just a deep dive into South American law. It's a necessary look at the foundational contradictions that any major global democracy faces when it's struggling with mass incarceration and, high-stakes economic crime.
That's absolutely right. Our sources are, they're from the proceedings of the 8th International Congress of Criminal Sciences.
Right, from PUCRS, the Pontifical Catholic University of Rio Grande do Sul.
Exactly. And while the theme was global criminology,
Right.
what these experts delivered was this really surgical critique of the Brazilian state. They focused on the crisis of punitive power, judicial activism, and just the general erosion of due process.
So our mission today is really to unpack the central conflict that you see across all of these sources. It's this constant high-stakes battle. On one hand, you have the democratic constitutional guarantees.
Things like privacy, due process, presumption of innocence.
All of that.
Yeah.
And on the other hand, you've got this relentless institutional pressure for what they call punitive efficiency. We're essentially charting the battle for democratic substance in real time.
And we'll cover everything from why traditional criminology just ignores genocide to how judges are, using legal loopholes to validate illicit evidence.
And the crisis of pretrial detention.
Oh, absolutely.
Yeah.
It's a huge one. It's a journey that really asks, how far can a state bend its own rules in the name of fighting crime before it just breaks the idea of justice itself?
Okay, so let's unpack this dense material and start at the most abstract yet most crucial level. So the organizers of this Congress centered the entire event around this enigmatic theme, global criminology. When you read these papers, it becomes clear they were challenging the very historical roots of their own discipline. What was the fundamental question they were raising about traditional criminology?
They were raising a question about scale and morality. Traditional criminology, as a modern academic discipline, was born and established within the structures of the modern civilized nation-state.
Okay.
Its historical job was to study crimes committed by individuals against the state or against fellow citizens, violations of the established national norms.
So the typical crimes you think of, the ones happening inside the walls of civilization as defined by that state.
Exactly. And the implicit assumption there is that the state is the good guy.
The defining force of civilization and order.
Precisely. And the core critique these scholars make is that by focusing so narrowly on this national internal focus,
And things like, bank robberies and homicides.
exactly, on those traditional crimes, criminology has consistently neglected. Well, it's remained structurally silent about the worst crimes.
Okay, stop right there. The sources use this terrifying phrase, geometric damage.
They do.
What scope of crime are we talking about when we move beyond that national boundary and get to this level of geometric damage?
We are talking about mass atrocities, things that cause damage that's just exponential compared to traditional crime definitions.
So not just one victim or a handful.
No, we're talking about massacres, genocides, massive violations of human rights that affect not dozens, but tens, hundreds of thousands, or even millions of people.
And that includes what?
That includes large-scale systematic torture, disappearances, mass rape, confinement, mutilation, and all of it often perpetrated or, facilitated by state actors or massive corporate entities.
And this is where the philosophical dilemma just explodes, doesn't it?
It does.
If criminology's job is to define crime, and the traditional assumption is that the state is the standard bearer of legality, how can the discipline even function when the state itself becomes the principal aggressor?
It creates a structural paradox that basically renders the entire field impotent. The traditional framework assumes the state sets the norms and administers punishment.
Right.
But when the state, through its public agents, police, military, political leaders, is the one committing the systemic aggression, the criminological definition of crime just breaks down.
How do you define something as criminal when it's being done by the very entity that holds the monopoly on defining criminality?
You can't. It essentially makes the state structurally immune to being analyzed by the tools it helped create.
That's a powerful insight. And it connects directly to geopolitical history.
Absolutely. The sources argue this structural blindness isn't an accident. It's fundamentally tied to colonial legacies.
How so?
Well, the mainstream criminological gaze, which originated largely in the global north and focused on European or American norms, it naturally avoids addressing mass injury that occurs in former colonies.
Or in these vast spaces of exception in the global peripheries.
Exactly, the global peripheries being where colonial dynamics still exert force.
So these are places still immersed in the legacies of slavery.
Entrenched authoritarianism and submission to more powerful foreign nations or, global capital. By focusing only on national penal law, criminology avoids addressing the most significant ongoing forms of violence that often originates externally or is structurally supported by the global economic system.
And this leads to this incredibly bleak yet necessary concept the Congress raised, the problem of human refuse. How does this concept broaden the scope of crime beyond state-sponsored torture to include, well, economic realities?
This takes the critique beyond just intentional violence and into structural violence. Human refuse refers to the broader systemic social damages that condemn millions across the planet to lives of just absolute indignity and disposal.
These are harms that are often ignored because they aren't written down as a specific penal offense, like murder or theft.
Exactly. So we're talking about economic policy acting as a weapon.
We are. The experts argue that this mass amassing of marginalized people, millions living without jobs, without adequate housing, healthcare, food access, or even the promise of retirement security, is a direct result of economic policies and market forces.
And the crucial point here is that these forces are today often more imposing than, or at least complicit with, state reasons.
This shifts the blame entirely away from the traditional model of just individual deviance. The crime here is systemic neglect, which is just coded as accepted economic policy, and it condemns entire populations.
Precisely. The core question for global criminology then becomes, what relevance does our discipline have if it is forever constrained by this narrow national scope in penal law?
Right.
If it doesn't address the social damages that condemn millions to be discarded, what one source called a permanent state of social death, then it is merely a tool of established state power.
So what's the revolutionary path forward they propose for this global criminology?
It's about detoxification and realignment. The discipline has to detach from its narrow fixation on national penal law and the punitive state.
And move towards what?
Instead, the future of criminology must align itself much more closely with the broader movements for human rights, for the strengthening of democratic institutions, and ultimately for popular emancipation.
So it means shifting the focus from simply punishing those who offend the state
to analyzing and dismantling the structures that perpetrate that geometric damage we were talking about.
The shift from that philosophical crisis to a concrete legal battle is immediate, and we have to start with the absolute foundation of due process, the inadmissibility of illicit evidence.
The first line of defense against state overreach.
Exactly. So let's start with the legal standard in Brazil.
The standard is, well, it's enshrined in the Brazilian Constitution, the Magna Carta, and it's reinforced by the Code of Criminal Procedure. It's an absolute rule. Evidence obtained in violation of constitutional or legal norms is inadmissible.
And the legal term for what must happen is desentrañadas.
Right. It means the evidence must be physically removed from the process file, torn out.
This is the critical mechanism, right? It's designed to disincentivize police or state agents from violating rights just to secure a conviction. If you cheat, you lose the evidence.
Correct. It's the adoption of the American exclusionary rule, which is often summarized as the fruits of the poisonous tree doctrine.
Meaning, if the primary evidence is tainted by illegality, say an illegal wiretap or an unauthorized home entry,
then any secondary evidence subsequently derived from that tainted source is also contaminated. It doesn't matter how relevant it is. The state cannot benefit from its own wrongdoing. That is the core democratic guarantee.
But the sources immediately flag that this guarantee, even though it's constitutional, has been severely weakened in practice by the legislature and the courts.
Severely.
So how have they created exceptions that allow this tainted evidence to creep back into the process?
They've done it through the legislative introduction of two specific exceptions. They were transplanted from American procedural law. But in the Brazilian context, they've become mechanisms to prioritize punitive efficiency over constitutional fidelity.
Okay, let's detail those. What's the first one?
First, we have the independent source. This exception applies if the prosecution can demonstrate that the evidence would have been produced by a source entirely untainted by the initial illegality.
So, for instance, if an illegal search finds a document
But investigators can prove they had already received an entirely separate legal discovery motion that contained the exact same document, then that document is admissible.
I see. And the second, often more expansive exception.
That's the inevitable discovery. This one is used when secondary evidence, even though it came from the illicit initial evidence, would have inevitably been obtained later by proper legal investigative means.
And that one is highly subjective.
Extremely. It allows the court to speculate on future legal action.
So if an illegal wiretap leads police to a hidden warehouse, the prosecution can argue, well, we were already legally monitoring the warehouse's utility bills, and those bills would have inevitably led us there within the week.
That is precisely the mechanism. It allows courts to retroactively clean up state misconduct.
And the critique here is sharp.
Very. The sources note a pervasive jurisprudential tendency to leverage these exceptions. They argue that the public interest in the successful criminal process, which really means securing a conviction, should prevail over the absolute nature of the constitutional guarantee.
And that shows the fundamental conflict we established at the start. Rights versus efficiency.
Exactly.
That tension just gets amplified exponentially when we talk about modern technology, specifically cell phones.
Oh, absolutely. They blur the lines between constant communication and stored personal data.
So what is the crucial legal distinction modern courts have to grapple with?
It's the difference between wiretapping, or intercept a sound telefonica, which requires a warrant and targets contemporary, ongoing communication.
And accessing stored data, which involves the past photos, emails, documents, and messaging history stored right there on the device itself.
And the key ruling that established a high bar for accessing that stored data came from the Superior Court of Justice, the STJ.
Tell us about that decision.
Yes. The landmark decision was RHC 51.531RO. The STJ explicitly recognized that accessing data and instant message conversations stored on modern smartphones without a judicial warrant constitutes a profound invasion of intimacy.
They use the word devasa.
They did, which means a total unrestricted ransacking of a person's life.
Why is a cell phone search so much more invasive than, say, searching a wallet or a traditional address book?
Because modern smartphones are, they're comprehensive repositories of our private lives. They hold intimate photos, videos, banking information, email accounts, private health data, and records of virtually every interaction we have.
So allowing police access without specific judicial oversight allows for a complete, constitutionally unacceptable devasa of the owner's personal history.
Exactly. The STJ recognized that these devices demand the highest constitutional protection.
Yet, we have this counter-paradigm from the Supreme Federal Tribunal, the STF, that just muddies the waters, particularly when it comes to arrests.
Indeed. The STF decision in HC 91.867 PA upheld the validity of proof obtained from searching a cell phone during a flagrant arrest.
And the logic there is what?
The logic is that the urgency and the immediacy of the arrest situation somehow justifies the search. And this illustrates the acute judicial conflict.
So, does the act of a flagrant arrest automatically override the constitutional protection afforded to this massive trove of data stored on that device?
That's the question. And how does that judicial conflict play out on the street? What does the average police officer do when faced with this ambiguity?
It must create a climate of permissiveness.
It does. And that's exactly what the sources criticize as state overreach. Because of this legal ambiguity, police authorities often use euphemisms to describe unauthorized data access or searches.
They label them what, Parisha?
Parisha, which is an expert examination or an exploratory search or a verification of elements.
So they're essentially using bureaucratic language to disguise an illegal act.
That's the core of the critique. These semantic maneuvers are designed to justify actions that are contrary to clear constitutional mandates. They're aiming to cloak the initial illegality in some kind of legitimacy.
And the overall result, the sources conclude, is judicial selectivity.
A kind of decisionism, yes, where fundamental rights are systematically overridden by the state's conflicting interest in securing a conviction.
And this fragility is evident even in something as basic as domicile inviolability, as you mentioned earlier, especially in sensitive cases like concealing a body.
Yes. The constitutional mandate is that a home is inviolable except in flagrante delicto or by judicial mandate.
Right.
But in cases of occultación de cadáver corpse concealment, where the person is already deceased, the urgency related to saving a life, the periculum in mora, is already gone.
So there's no immediate danger.
None. But police often enter without a warrant, claiming flagrant circumstances. But that flagrancy relies on subjective secondary factors like anonymous tips, smells, or past history.
The sources cite the STF's requirement for fundadas razões, founded reasons, for entry. But the argument is that these reasons are often just defined after the fact to justify the illegal entry.
Exactly. And it just highlights how subjective and fluid the interpretation of constitutional guarantees becomes in practice. The judiciary allows the investigative wing to operate with immense discretion, which is a hallmark of an inquisitorial system, not one based on strict constitutional observance.
The legal instability we just discussed concerning evidence feeds directly into what the sources describe as a massive structural failure of the Brazilian punitive system.
And it starts with the sheer scale of incarceration.
Let's look at the numbers.
The scale is, well, it's alarming. The data cited from 2014 showed Brazil already had the world's fourth largest prison population. We're talking 622,202 individuals.
And given the country's economic and democratic status, that number alone signals a profound societal commitment to hyperpunishment.
Right. It's often replacing social policy with penal control.
But the truly acute crisis isn't just the final convicted population. It's the enormous proportion of people being held before they've even had their day in court.
The pretrial crisis. This is a major structural failure. Approximately 40% of the total incarcerated population consists of pretrial detainees, or presos provisorios.
40%.
Yes. And to put that in perspective, the global average is closer to 25%.
So Brazil is holding nearly double the international standard for people just awaiting trial.
They are. And those official numbers are artificially low because they often exclude people held in unauthorized police facilities.
Right. The sources highlight that the problem is routinely understated.
For example, in Rio Grande do Sul in 2017, there were 264 prisoners being held in police stations and even police cars, often in just inhumane conditions.
Handcuffed to waste bins.
Things like that, yes. Simply because the prison system has no room. This is incarceration by administrative decree outside of the official penal framework, and it speaks volumes about the indignity built into the system.
And the length of this detention is a form of preemptive punishment.
Absolutely. The data shows the average wait for judgment in states like Rio Grande do Sul is 1 year and 3 months.
437 days.
Right. And this extended pretrial detention often, if not routinely, exceeds the likely eventual sentence the person would receive if they were convicted.
So you are effectively serving a sentence before a conviction solely based on the assumption of guilt.
Which is a fundamental reversal of the presumption of innocence.
Now let's focus on the demographic shift, specifically the staggering rise in female imprisonment, which the sources argue is a key indicator of systemic social control.
The statistics are horrifying. Between 2000 and 2014, the number of incarcerated women increased by a staggering 567%.
567%.
Yes, reaching 37,380. And the academic analysis here is critical. This surge is not simply a necessary corollary of public safety.
What is it then?
It is largely viewed as an instrument of social control, rooted deeply in the patriarchy of Brazilian criminal policy.
How does that patriarchy operate within the penal system?
It functions by reinforcing traditional gender roles. When women, often driven by economic desperation linked to drug trafficking or associated low-level crimes, are subjected to preventive detention, the system is fundamentally punishing them for leaving the private domestic sphere.
Punishing them for stepping outside expected societal boundaries of caregiving and domesticity.
Exactly. And that is why the structural deficit in their facilities is so severe.
Can you elaborate on those structural deficits?
Well, the system simply wasn't built for women, and the neglect shows. Only 7% of facilities are exclusively for women. A shocking 17% are mixed gender.
Which is an explicit violation of safety and human rights mandates.
It is. And furthermore, nearly half, 49% of female-only facilities lack appropriate dormitories for pregnant women, and 48% lack nurseries or maternal infant centers.
This isn't a flaw. It's a structural denial of their reproductive and maternal reality.
And that demonstrates a punitive rather than a rights-based approach.
One of the major reforms intended to address this pretrial crisis was the custody hearing, the Audiencia de Custodia.
The AC.
What was its clear mandate?
The AC was a vital introduction, mandated by the American Convention on Human Rights, the Pact of San Jose, and formalized domestically. The mandate is unambiguous. Any person arrested in flagrant must be brought before a judge within 24 hours.
And the purpose?
To review the legality of the arrest and to confirm the physical integrity of the detainee, ensuring no torture or abuse occurred.
And initially, the results seemed to demonstrate its value, right?
The initial data was highly encouraging. The CNJ reported a massive economic saving, $4.3 billion in 2015 alone. because judges were correctly applying alternative measures instead of automatic preventive detention.
It also highlighted the high rate of error.
It did. Data from Rio de Janeiro showed that 54.4% of people arrested and held for over 101 days were later freed or had their processes archived. The AC was acting as a necessary filter against illegal detention.
But the sources indicate that implementation hit a wall of judicial resistance.
Yes, the failure lies in noncompliance and, judicial flexibility. Courts in states like Rio de Janeiro and Paraná started intentionally using vague, dilatory language.
What kind of language?
Phrases like, without delay, or on the first business day, instead of rigidly enforcing the 24-hour limit stipulated by the resolution and international pacts.
And that seemingly small legal loophole has massive human consequences.
Immense consequences. A person arrested late on a Friday or before holiday weekend can easily be illegally detained for 3 or more days before seeing a judge.
And this deliberate semantic maneuver contributes directly to the overcrowding in police stations.
And it perpetuates the illegal detentions the AC was designed to prevent. Paraná was explicitly cited for having an exceptionally high number of prisoners in police stations, many of whom were provisional detainees awaiting a hearing delayed by this very judicial noncompliance.
Finally, within this system focused on vulnerable groups, we need to address juvenile justice and the practice of the informal hearing, the oitiva informal.
The oitiva informal is a pre-procedural hearing conducted by the public ministry, the MP. It was conceived as a procedural guarantee, a gatekeeping mechanism.
So the MP can opt for non-prosecution if, for example, the facts are weak.
Or if a formal judicial procedure is deemed unnecessary. It was meant to mitigate historical violence against youth by keeping them out of the punitive system entirely.
In theory, a progressive tool. So where does the institutional failure lie here?
The central failure is legislative omission. There is a critical lack of specific legal regulation defining the form, purpose, and required attendance for this hearing.
A vacuum.
A huge vacuum that creates enormous space for ministerial and judicial discretion.
And when the law is silent, discretion often gives way to authoritarianism.
Precisely. In practice, this lack of structure results in the suppression of fundamental rights, like the right to a contradictory defense or legal certainty.
So the old system persists.
Exactly. The sources argue that despite the constitutional shift from the old irregular situation doctrine to the new framework of integral protection in 1988, the older, authoritarian, non-rights-based institutional framework persists.
And the proposed solution?
Mandatory formalization, specifically requiring the presence of a defense lawyer to delineate clear legal limits and protect the adolescent from arbitrary decision-making.
If the core problem is this inquisitorial nature embedded in the law, that problem is vastly amplified by external pressures. Let's look at the media's role, what the sources call the spectacularization of the criminal process.
This phenomenon is deadly to due process. The media treats information not as a service, but as a commodity. It relentlessly prioritizes sensationalism, audience ratings, and commercial gain over core constitutional guarantees.
Particularly the presumption of innocence.
Absolutely. The judicial proceeding itself is transformed into a spectacle, a drama where the audience demands a swift, satisfying ending.
We see this globally, but the sources point to specific Brazilian cases where public opinion rendered a verdict long before the judge did.
For sure. The intense, guilty-before-proven innocent coverage of high-profile cases like the Isabella Nardoni murder and the Bruno Fernandes case are prime examples.
How so?
The media crafts these compelling, often simplistic narratives like portraying the accused as having a cold personality that dictate public perception, imposing a societal stigma that prejudges the individual.
And this public demand creates a feedback loop that fuels political policy.
It is the engine of penal populism. This process is reinforced by simplistic, high-volume slogans, particularly from sensationalized news programs called policialescos.
And they constantly disseminate maxims like,
the police arrest, the justice releases. This rhetoric actively erodes public trust in the established justice system, making the public demand harsher measures, hyperpunitivismo.
Which bypasses legal checks and divides society sharply into good people and criminals.
Exactly, it's toxic. And the sources note that public authorities often collaborate in this abuse by leaking confidential data.
This is a severe indictment of the system's integrity.
It is. In major operations like Lava Jato car wash, the press frequently had access to confidential data, plea bargains, and evidence before the defense lawyers were legally allowed to review them.
So this collusion between investigators and the media actively compromises the fundamental right to a fair defense and due process.
It creates a structurally uneven playing field.
Yeah.
The information is controlled and weaponized.
This external pressure is easier to internalize because, as the sources argue, the Brazilian legal structure already has an inquisitorial DNA. Let's contrast that core structure.
Okay, so we have to contrast the two ideal models. The democratic accusatory system requires three things: an impartial judge, who is a passive referee,
Proof managed by the parties' prosecution and defense.
and a strong presumption of innocence.
Yeah.
The older authoritarian inquisitory system, conversely, features a judge who accumulates multiple roles.
Accuser, investigator, and adjudicator.
Right, and the process is often secret. And the critique is that the 1941 Code of Criminal Procedure, the CPP, despite numerous democratic updates, remains fundamentally inquisitorial and systematically incompatible with the democratic 1988 Constitution.
That is the core conflict.
And the CPP retains specific, highly problematic provisions that maintain this inquisitorial nature. The most glaring example is the judge's power to determine evidence production ex officio.
On their own initiative.
On their own initiative. The judge is supposed to be the referee, but this power allows them to actively step into the game, put on a jersey, and start seeking evidence to help one side, which is usually the state or prosecution.
So this combination of roles facilitates judicial decisionism.
Exactly, where judges make choices not strictly based on legal interpretation, but based on subjective beliefs, political alignment, or the societal pressure for convictions.
Then there's more.
Yes. The judge can also reject the public ministry's request to archive police inquiries, forcing a case to continue even if the prosecutor deems it weak. This enables the judge to compel the process forward, blurring the lines between impartiality and accusation.
And this judicial decisionism is what led directly to the profound instability concerning the state of innocence itself. The constitutional rule is crystal clear. Innocence lasts until the final, unappealable decision, or transito emulgado.
That is the sanctity of the constitutional guarantee. Yet the sources detail the hugely controversial STF decision HC 126.292 SP, which allowed the execution of a sentence to begin after a second-degree conviction.
Even if the highest appeals were still pending.
Even then.
That sounds like judicial activism operating at a seismic level, reinventing a centuries-old procedural concept.
It is widely criticized as such as an institutional instability that violates legal certainty. Critics argue that the Supreme Court aligned itself politically with punitivist demands fueled by the media spectacle.
Sacrificing the core principles of democracy and legal security.
Exactly. It's the highest court, the institution meant to guard the Constitution, instead becoming the mechanism for its erosion by prioritizing efficiency and the immediate gratification of punishment over democratic substance.
If the idea of transito emulgado means that the state must exhaust every possible legal avenue before removing a person's liberty, what is the strongest counterargument that proponents of this decision offer to justify provisional execution?
Proponents argue that the sheer volume of frivolous or purely delaying appeals, especially the recurso extraordinario and recurso especial, filed simply to postpone incarceration.
Particularly by high-profile defendants in corruption cases.
Right. They argue that this fundamentally undermines public trust and judicial efficiency. The argument is that after two layers of judicial review, the trial court and the appellate court, the probability of innocence is statistically low enough to justify the execution of the sentence.
Thereby ensuring justice is swift and visible to the public.
That's the idea. But the sources fundamentally reject this. They argue that allowing the possibility of error to lead to the removal of liberty is precisely what constitutional guarantees are designed to prevent.
So they see it as sacrificing the rule of law for political expediency.
Yes, thereby confirming the persistent authoritarian nature of the state apparatus we were just talking about.
Let's turn our attention to the complex world of high-level economic crime, where the rules of the game shift entirely. The investigation of organized corruption relies heavily on collaboration tools like leniency agreements and plea deals.
Or delays in premiata, yes. But these agreements run into a hybrid dilemma.
What's that dilemma?
It arises because economic misconduct often involves acts that are simultaneously a criminal figure, a penal offense, and administrative improbity, a civil or administrative offense. The key conflict is jurisdictional separation.
So if a corporate executive collaborates with the criminal prosecutor, they confess, name names, and get a reduced prison sentence or fine in the criminal sphere, does that deal protect them from non-criminal penalties?
No, and that is the systemic anomaly. The collaboration agreement celebrated in the criminal sphere does not automatically extend to cover sanctions in the civil and administrative sphere.
Which are governed separately.
Right, particularly by law, 8.4291992. So the collaborator remains fully subject to potentially ruinous administrative penalties.
Why is this separation viewed as a critical anachronism that sabotages the system's effectiveness?
Because for large corporations or executives, the administrative penalties, we're talking massive multi-million-dollar fines, asset freezes, disbarment from contracting with the government for decades, or even dissolution of the company.
Those are often far more financially devastating and reputationally crushing than the criminal prison sentence.
Far more. So the state creates a system intended to promote collaboration to fight corruption, but the parallel system of administrative law effectively eliminates the incentive.
It seems counterproductive.
Absolutely. If collaboration doesn't provide comprehensive legal security across all jurisdictions, it drastically discourages individuals and entities from cooperating. This hinders the crucial fight against systemic corruption and fiscal control. It ends up penalizing entities twice for the same set of facts, leading to paralysis instead of resolution.
This complexity is reflected in how they handle corporate criminal liability. It's often impossible to pin a massive economic crime on a single, identifiable person in a complex structure.
And this difficulty forces a move toward holding the legal entity, the corporation, responsible. The sources contrast two models here.
Okay.
The traditional heteroresponsibility model assumes liability must be transferred from an identified natural agent, like an executive or employee.
But the emerging and necessary model is the auto-responsibility model.
Right, where liability is based on the failure of the company's internal organization or compliance structures, regardless of identifying the specific person responsible.
Since modern corporations are so vast, the auto-responsibility model based on organizational fault seems essential for accountability.
It is the only practical way forward, and the sources use the Barcelona FC case, the Neymar 1 contract investigation, as a perfect illustration.
The club, as a legal entity, along with its former presidents, was accused of unfair administration and tax crimes related to the players' acquisition.
Right.
What was the outcome, and how did it reflect that auto-responsibility model?
The outcome really demonstrated the priority of organizational culpability. The club assumed all responsibility for the crime. It agreed to pay a €5 million fine plus damages in exchange for exempting the physical persons, the former presidents, from penalization.
I see.
This settlement, combined with the club's robust commitment to implement a formal compliance program, shows the system prioritizing the correction of organizational failure.
The auto-responsibility model.
Right. It's over individual penalization. It allows the state to capture significant fines while avoiding lengthy, complex trials against specific individuals.
Finally, we turn to a highly controversial legislative proposal, allowing the civil party, the victim, to seek damages directly within the criminal procedure.
Moving toward jurisdictional integration.
Exactly. This proposal, PL 8.045201, aims to integrate the processes, allowing the victim, the vitima, to join the criminal proceeding to seek civil damages. On the surface, it seems intuitive. Efficiency for the victim.
Right. If someone defrauds me, why should I have to file two separate lawsuits?
So what is the fundamental democratic critique against integrating civil and criminal interests?
The critique is that this integration is deeply incompatible with the necessary structure of a democratic criminal procedure. The criminal process is fundamentally a conflict between the accused and the state.
A process designed to be one of unequals.
Yes, where the state's immense punitive power must be contained by stringent constitutional guarantees. Introducing the victim changes the focus entirely.
How so?
It fundamentally subverts the process. Introducing a victim with private, patrimonial interests risks transforming the process's true purpose, which is punishment applied for the collective good, governed by public law, into a vehicle for private compensation.
It elevates the victim's personal economic interest over the accused's constitutional guarantees.
And it could potentially pressure the accused to accept a conviction just to avoid a ruinous civil judgment.
The sources trace this reform tendency back to some deep philosophical roots, neoliberal economic theory.
They connect it explicitly to thinkers like Gary Becker and Richard Posner, who treat crime as an economic externality.
And in this economic calculus, the solution to crime is compensation.
Or establishing the correct price. This perspective strips crime of its moral dimension, reducing it to a cost to be managed rather than a moral wrong requiring a strictly measured state response.
And what is the historical perverse outcome of applying this economic logic to the punitive system?
It exacerbates social selection. The sources argue that when compensation is prioritized, the historical outcome is the mass incarceration of those unable to pay the compensatory fines, the poor.
And Posner even noted this outcome.
He did. Later in his career, he noted that the system of penalizing underclasses, those excluded from the market, results in mass incarceration becoming the primary tool of risk prevention against those who cannot afford the compensatory price.
So in the Brazilian context, this tendency just reinforces the existing social selection.
It does. The poor are overwhelmingly subjected to the punitive process because they lack the financial means to buy their way out or compensate the victim.
This has been a tremendously dense yet illuminating deep dive. The collection of sources from the PUCRS Congress has laid bare the internal battles raging within a major democracy like Brazil.
The synthesis is this constant high-stakes collision. It's between the guaranteed, slow, deliberative democratic process and the demanded, rapid, punitive outcome.
Right.
We saw the structural violence of global criminology linked directly to the willingness of the judicial system to bend its own constitutional rules on evidence in custody, all in the name of expediency.
We've seen the very institution meant to safeguard the 1988 Constitution, the STF reinventing concepts like transito em julgado, effectively aligning with penal populism.
We saw pretrial detention acting as preemptive punishment and the structural neglect of women's facilities.
The sources fundamentally confirm that the inquisitorial legacy is still deeply embedded in the Brazilian state.
It is. And it seems to win out over the democratic mandate whenever the pressure for punitive efficiency is sufficiently high.
Whether that pressure comes from the media spectacle or from the desire to resolve massive corruption quickly.
Exactly.
So what does this all mean for us? This struggle between democratic substance and punitive speed is playing out in every democracy around the globe. What is the final provocative thought we should leave with you, the listener, as you consider these legal fault lines?
Well, the experts make it clear that procedural guarantees, like the sanctity of evidence rules or the right to the presumption of innocence until the final appeal, they are not just technical legal formalities.
No, they are the substance of democracy itself.
They are. So if the state continually strips the criminal process of those foundational procedural guarantees in the name of fighting crime faster or more efficiently, can we still rightfully call it a process of justice?
Or have we reduced it to merely an instrument of authoritarian power, regardless of whether the target is high-level corruption or low-level drug offenses? A vital question for anyone concerned with the rule of law. Thank you for taking this deep dive with us.